Welcome back, everyone. So today we're going to be taking a look at the Lori Vallow case again. In particular, we're going to be talking about the Lori Vallow's attorney, Mr. Means, and the whole slew of motions that he has recently filed in this case that will be heard tomorrow, Wednesday, the 17th of February. And they get more and more bizarre as this thing goes along. But let's go ahead and jump right into it and take a look at this case. And thank you for joining me today. Okay, first off, Mr. Means has filed a slew of motions and for discovery in this case, saying that he has not received a whole litany of different things in this case that are supposed to be shared with the defense, that the state is somehow holding back the evidence from him so he can actually give Lori Vallow a proper defense on the motions that are for the case for her and Chad, the actual felony case, not the misdemeanor case, but the felony case. He is saying that has not received the proper discovery motions, even though everything in this case, discovery-wise, has been sent to Mr. Pryor, Chad Daybell's attorney, and he received it back in May of 2020. Mr. Means has now filed a slew of requests with the court. And it's kind of bizarre how he's gone about doing this, because the normal course of action is if you're going through your actual discovery, if you're an attorney, the discovery motions, and you're laying out all the witness statements and everything else that needs to be done in a case, you write it down and you're like, okay, where's this discovery? And then you look in your files and everything else through the discovery and all the things that you have. And if you don't have something, then maybe you pick up the phone and you call the prosecuting attorney or the fellow co-defendant's attorney. You call them and ask them for the documents. Do you have this piece of discovery? Do you have this witness statement? Do you have this interview? That would be the normal course of action, but not for Mr. Means. Oh, no, 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 not for Mr. Means. Mr. Means, instead of making a phone call or sending an email or asking anyone else for the documentation, he just goes straight to the court and cries like a little baby and says, hey, I never got this. I don't have this. Where is it? Make them give it to me. I want it now. That's Mr. Means for you, ladies and gentlemen, acting like a spoiled little brat because he can't find something. The normal course, again, you check once, you check twice, you check three times in your actual records to make sure you don't have it, or you call the co-counsel in a case like this and ask them if they have it. And we'll get to Mr. Pryor here in just a little bit. But he has filed and said that he has not received, several pieces of discovery, and that the state is actually withholding this information from him. And he wants the court to compel the prosecuting attorney to turn over this evidence. Yeah, that's the first one. There's a whole slew of actual motions that he has filed that is going to be dealing with just that part. But the other thing that he is asking the court to do, the court to jump into, intervene with, is the cell phone record. The cell phone again. He is requesting the court to take a look at Lori Vallow's request again, even though the same judge has already ruled on that she can't have a cell phone because it would be considered contraband in the county jail where she's currently located. It'd be contraband for her to have a cell phone there. He wants the court to look at the motion again. Now, generally speaking, the courts do not like to rehash things that they've just recently ruled on a couple weeks ago, unless there is a new circumstances that has been, that are being brought up, like they can prove that more phone calls between, client and client and attorney have been recorded, and they haven't been. But he would have to prove that something like that is still ongoing, even though there was one phone call that was recorded and has since been deleted, and everything that could have been learned from that has been stricken, and it can't be brought into the case at all to prosecute Lori or to prosecute Chad. But there was that one phone call in the early beginnings after she was extradited back. There was one phone call that was recorded, and nothing has been recorded since then. And matter of fact, in the motion itself, Mr. Wood has filed an addendum to it and said, look, there is a recording that comes on the phone when you make a phone call from your client places the call to her attorney. There is a phone call that actually records and plays before the phone call is actually completed that says the following, and this is an exact quote. This phone call may be monitored or recorded, and then lists off the name of the actual jail where she is. And that, end quote, that plays before the phone call is ever connected to the second party. So Lori knows immediately if the call is being recorded. So she has no grounds to file to have them hear it again on if she can get a cell phone. Moving on from there. Next thing that they're going to bring into court on Wednesday is Mr. Means' bizarre series of tweets. Yes, we all know that Mr. Means took to Twitter to, I guess, unduly influence the court to reconsider the cell phone, request, even after they ruled on the request that she couldn't have the cell phone. He took to Twitter and posted a series of things about, he's not able to communicate with his client effectively because of the phone and the way that the meeting rooms are, and he wants them to reconsider their motion to decide that she can't have a cell phone again. That's going to be brought up in court on Wednesday, and the judge is going to rule on, hey, buddy, you can't do that. You can't go around, taking it to Twitter or to social media. If you want to say that, look, this case has gotten too much press coverage, and it may be hard for you to get a fair trial for your client. Maybe what you should do is stay off of social media and bringing more and more attention to this every day. There's an idea, Mr. Means. Why don't you try that? Mr. Pryor and the burn. Mr. Pryor filed a motion along with the papers that the DA, not Mr. Means, but Mr. Pryor filed a letter along with the DA that said, we haven't had any problems at all. I've had absolutely no problems communicating with my client. I've had no problems with the jail there recording our phone calls. I have had no problems getting discovery from the state. I've had no problems with getting evidence and speaking with witnesses that they plan on calling. And yes, Lori is in the one's in Fremont and one's in Madison County, jail. They're in different jails, the two of them, Chad and Lori. But he basically attached the letter saying, look, I have no part of what this wacko is over here, Mr. Means, is doing. I don't want you to drag me into this at all. I just want to make it and put it out there on the record that me and Chad, Mr. Pryor writing the letter for, in behalf of Chad, we've had absolutely no issues at all with communication and discovery or any aspect of this case at all, and we're ready to go forward. where Mr. Means has been dragging his feet and kicking up dirt as he goes along and really ticking the court off and ticking off obviously Mr. Pryor to the point where Mr. Pryor felt that he needed to attach this letter not through Mr. Means along with his motions but send it directly to the actual court, and have the prosecuting attorney have it, so when he goes into court, he can say to the judge, well, Mr. Pryor has had no issues with getting discoveries or anything else in this case. We don't know what's going on with Mr. Woods. Mr. Means. Mr. Woods saying to Mr. Means, I have no idea what's going on with him in this case. But Wednesday, there is going to be a court case, and there are several different true crime channels who are following this, who will have a live feed of the actual court case on Wednesday. And you can, if you want, you can go over on to Crime Talk with Mr Reich, and he will actually have it live. So I depended upon your time zone. I put the time up here on the screen. I don't know what time. I know the court case starts at 9:30 a.m. Pacific Daylight Time, or maybe they're Mountain. I'm not exactly sure myself on the time zone differences, but you can check it out by just a simple Google case. Lori Vallow, Wednesday court case, the 17th, 9:30 a.m. What time is that in my zone? And so if you want, you can watch it live. I will not be here in town to actually, live stream that. So that's why I'm telling you about other channels. That besides Mr Reich, does a damn good job at this, content. So thank you everyone for joining me today. You have a terrific week. Oh, quickly, you wanted to know why am I dressed like this? Well, ladies and gentlemen, this is what I look like when I go to court. And I am not a defendant. I am not a prosecutor. I am nobody. I am here to dig up the documentation for you, the viewers. I do this for you. And yes, earlier today, I was in a courthouse and I was requesting documentation on a case that I am researching for you. And this is how I dress. It's not a complete three-piece suit, but it is a shirt, and I have a tie, and you've always seen the ties in the background, like that one right there. I wear a suit when I go to court because I am a professional, and I am here for you to get the documentation that you deserve and that you want. Oh, that's the end of the video. I hope you enjoyed it. If you did, I would really appreciate it if you'd give this a thumbs up, and let YouTube and the algorithm know that you enjoyed this content. If you have only watched one video and this is it, well, thank you for stopping by. But I have a whole channel of over 500 videos for on YouTube right now. Why don't you go check one out? Links down below. There's a next suggested video there. You can subscribe too. I wouldn't mind if you would do that.